The opening phase of this hearing reveals something important about the department's strategy. Instead of leading with emotional claims, they begin with neutral law enforcement testimony and documented injuries.
Teen.
Would you agree he is a minor?
Yes, ma'am.
And would you agree he's either 15 or younger?
Yes, ma'am.
Okay, so none of the children in the home that we've identified here are adults, is that correct?
Yes, ma'am. Not none of them are.
Okay, and the youngest children are the Miles children, is that correct?
That's correct.
Thank you. Now, during that investigation, what did the department end up doing regarding placement of the children to try to ensure their safety?
There was parental child safety placements that were entered for two of the children, for Odyssey and Zanaya. And then Aaliyah, she was initially in a parental child safety placement, but then went to stay with her father at the time.
Okay, and the Miles children were living with their father, is that correct?
Yes, ma'am.
And he had agreed to keep him there and to keep them safe, is that correct?
That's correct.
Thank you. Let's see here. And from that investigation, the court ordered Ms. Johnson to participate in the family-based safety program. Is that correct?
Yes, ma'am.
And that is where you stepped in as a worker. Is that correct?
Yes, ma'am.
Great. Can you tell me about the services that Ms. Johnson was offered in the family-based safety program?
Yes, ma'am. She was offered parenting, rational behavior training course. We did have concerns with substance abuse, so she was referred to complete an OSAR assessment. Through that OSAR assessment, because it is self-reported, any type of recommendations that are given are via the self-report. There was no recommendations at that time. She also was attending the domestic violence support group and their individual counseling as well as family counseling.
Okay, so it sounds like the department was attempting to address her parenting skills. Would you agree with that?
Yes, ma'am.
The domestic violence with her as a victim, is that correct?
Yes, ma'am.
Okay. Um, did the department also have concerns regarding her as a perpetrator of violence?
Yes, ma'am.
And how is the department trying to address that?
So we had made a referral over for the WAVE program, which is sort of like BIP. It's for women who are perpetrators of violence. And because the report of her stabbing Kevon was dropped, because those charges were dropped, they were not willing to accept her into the WAVE program. So we made recommendations through her therapist that she complete an anger management course with her counselor.
Thank you. And was she working on that as well?
Yes, yes, ma'am.
So on paper, would you agree that, during that order to participate in services case that she was working her services?
Yes.
Can you tell me about the outcries that the children made during your family-based safety services case to you?
Yes. So the kids, the Miles children had reported concerns, specifically Jacoria, Malaysia, of violence by Miss Johnson towards them. They'd indicated that she had hit Jacory in the face and busted his nose, that she had hit him with the broom and with the belt on various occasions. Malaysia had reported fear of Kia. From what all the children said, including the three older ones, Malaysia was the one who was targeted for most of the abuse. At one point, they indicated that Miss Johnson had punched her in the mouth and knocked out one of her teeth. And I know even in speaking with the school, there was concerns with her behaviors while she was attending school here in the Amarillo area, um, due to the abuse that she was that was going on in the home. It was kind of coming out in her behaviors at school.
So is it fair to say we had at this point concerns of violence, her violence with the children and substance abuse? Can you tell me about the concerns about Ms. Johnson's substance abuse?
Yes, there was various reports that she was drinking excessively, and then during these times she was engaging in fights with other individuals. Of course, she didn't report this during the OSAR assessment, but it did come out from the kids that she was drinking and being out pretty late at night.
And when you say OSAR assessment, is that a substance abuse assessment?
Yes, ma'am.
And that was one of the services that the department asked her to complete and that she completed. Is that correct?
Yes, ma'am.
And are those assessments based on the client self-reporting?
Yes, ma'am.
And so if Ms. Johnson hypothetically didn't disclose any of this, do you think that would affect the results?
Yes, absolutely.
Thank you. What were the struggles with keeping the children placed with Mr. Miles during that family-based safety services case?
So the kids did report not wanting to even visit with Kia, let alone return to her care. And because at the time there was an order in place that she was primary custodian, she continued to make threats that she was going to get the children from him without any type of agreement between them.
Okay. And under those circumstances, in addition, let me withdraw that question. What occurred towards the end of that family-based safety services case that caused alarm for the department?
So there was a couple of incidents that we received police reports on in which Miss Johnson had continued to engage in domestic violence and physical violence towards other people. And during those incidents, there was continued alcohol use on her part.
And were those incidents, did they include what was testified to by Officer Lewis and Officer Ward here today?
Yes, ma'am.
Okay. And Elaine, have you reviewed petitioner's exhibit number 5?
Yes, ma'am.
And does that appear to be the law enforcement incident report regarding Kia stabbing K1ds with scissors?
Yes, ma'am.
Your Honor, I offer petitioner's exhibit 5 as evidence.
All right, objections? All right, petitioner's 5 is admitted.
Thank you, Your Honor. Now, Lane, when did this family-based safety services start?
Let's see. It started, my initial assessment with her was July the 30th
Okay.
of 2025.
And these cases typically last about 6 months, is that correct?
Yes, ma'am.
And then in December, these 2 incidents occurred, is that correct?
Yes, ma'am.
When did the department find out about these 2 incidents?
Andrew Miles approaches the case from a position that courts typically find persuasive. He is not arguing over technicalities. He is arguing from stability. His testimony centers on what the children reportedly experienced and how those experiences changed their relationship with their mother.
So they were right before the final hearing. We were coming up for potential closure, and it was literally the morning of one of the hearings that we had.
Okay. And based on that, did the department determine that the children were in immediate danger?
Yes, ma'am.
And was that for their physical health and safety?
Yes, ma'am.
And a big contributor of that was Ms. Johnson not agreeing to leave the children with Mr. Miles. Is that correct?
Yes, ma'am.
And Mr. Miles had an ongoing Office of the Attorney General filed case to try to get custody. Is that correct?
That's correct.
However, those hearings kept getting continued. Is that fair to say?
Yes, ma'am.
And so there was no court order in place to ensure the safety of the children from Ms. Johnson. Is that correct?
That's correct.
And
Let me interrupt for a second. Ms. Johnson just entered the waiting room. All right, for the record, the mother, Kia Johnson, has now joined the hearing. Ms. Gutierrez, go ahead.
Thank you, Your Honor. Let me make note of that on my stuff too. All right. So Elaine, can you tell me about the reasonable efforts the department made to try to prevent removal?
Yes, there services provided, parental child safety placements that were entered. During the investigation stage, there was several safety plans that were put into place that were broken, which caused family base to become involved. There was an order to participate that was sought. We did include quite a bit of relatives and friends to try to assist in those temporary placements.
All right. However, the children were ultimately removed. Is that correct?
Yes, ma'am.
And is it correct that they were removed with orders?
Yes, ma'am.
And what occurred once the children were removed regarding the older three children, Aaliyah, Zanaya, and Odyssey?
Ms. Johnson denied the department access to the children, and she took them and ran with them for a few days. So it took us a while to locate them.
And does that cause you concern with any potential in-person visitation for Ms. Johnson with any of the children?
Yes, ma'am.
All right, I pass the witness.
All right, Ms. Molnatz.
Ms. Lucero, you were the worker for the entire case, is that right?
For the family-based case, yes, ma'am.
Okay. And during that family-based case, was Ms. Johnson having supervised visits with the kids, I guess maybe in Dallas or online or something?
Yes, there was virtual visits between her and the Miles children. And there was one face-to-face visit that occurred where she went to Dallas to see them.
And at some point, was there, I guess, a statement to you from Mr. Miles that during the visit that Ms. Johnson was very intoxicated?
Yes, during one of the virtual visits, which at that point, following that, I started supervising those virtual visits every week.
And so during your supervision of those virtual visits, were there ever any concerns?
There was some disagreement between the parents at one point, but I do know during the visits, it was usually only one of the children, the youngest one, Amaya, that would get on. The other two children, either they would get on for a few minutes or they wouldn't get on at all. They didn't want to have contact with her.
So when the kids would get on, what was their demeanor toward their mom?
Just hi. With the two older ones, with Amaya or with Malaysia and Jacori, they would just tell her hi, really brief. At times they would get on because she would ask Amaya to go and get them, and they would, get on for a short period of time. Amaya was really the one who would talk to her about school and activities that she was involved in down there. But she was really the only one who attended those visits.
And so she did well in the family base, but then there started being other issues, right?
Yes, ma'am.
I pass the witness.
All right. Ms. Johnson, do you have any questions for Ms. Lucero?
Yes, sir. During the time where I was on the phone, was there any concerns of like, oh no, let me ask this. During where it was a claim that I was intoxicated during that visit, do you know that Andrew Miles was not on the video and it was Tiara, his I think it's his girlfriend or fiance?
Your Honor, I'm going to object to Ms. Johnson at this time. It appears that she's driving in the vehicle. I feel like I can see things flying by
I'm
the window.
hands-free. I'm hands-free.
Your Honor, I think it's illegal to drive with a video
Ms.
conference.
Gutierrez, that's not my problem. That's Ms. Johnson's problem. Let's go ahead. Go ahead, ask your question, Ms. Johnson.
Were you aware that Andrew Miles was not in the video whenever Amaya was on the phone call during that virtual visit where he said I was intoxicated?
Yes.
So I remember from our last hearing, he had also made a statement saying that he had seen a drink in my hand, which would be impossible if he wasn't in the video, correct?
I don't know what the last hearing was involved, but there was other reports from people who were present in your home during that visit who informed me that you were intoxicated.
Did that have any effect on the phone call that was taking place if I was intoxicated?
Yes.
And how so?
From my understanding and speaking with you and the text message you received, there was an argument that ensued. And at that point, not only you, but Andrew had asked me to supervise those visits moving forward.
Okay. Do you know what the argument was about?
I believe from what I was told, Amaya was crying at the time.
And why was that?
I believe she had said she had wanted to see you or come home, something of that nature.
The statement was, how come the other kids get to be there and I don't?
You're breaking up, Miss Johnson. We can't hear you.
Okay. Statement was made was, how come the other kids to be there and I don't?
Miss Johnson, you're breaking up. We can't hear you. You're breaking up.
Okay, let me pull over. Sorry, Judge.
A major turning point emerges when the discussion shifts from custody to termination of parental rights. That is a completely different battlefield. Seeking sole custody is one thing. Supporting termination, even when it eliminates future child support, creates a different impression.
Yes,
Can you hear me now? Okay. The statement that was made was, how come the kids get to be there and I don't? Do you recall that statement?
I wasn't present for that visit, so that's the text message that I received from you saying that that's what she had said.
Okay. And are you aware there's a screenshot of her breaking down crying during that visit because she wanted to be there?
No.
Okay. During the family-based safety plan, how was I doing according to like being a parent and parenting the kids? And can you describe my parenting during that time?
During my contact with you at your home, whenever I would come out for visits, things seemed fine. But that was during my visits that were scheduled with you and the kids.
And you were allowed to pop up whenever you wanted, right?
Yes.
Was there ever any issues with me telling you, no, you can't come see the kids or anything during that time?
No.
Okay. Whenever the issues happened in December, were there any problems with my parenting during that time as well?
During the police report incidents?
Yes. Mm-hmm.
During my visits with you, no, but I would say there is concerns that there was police reports coming back.
Okay. No, now were those police reports concerning the kids? Were the kids ever in any danger?
I would not know. I wasn't there every day to say yes or no.
I mean, I'm for the most part, like every time you showed up, if you could say yes or no during the first part of it, before those reports, how come you cannot say yes or no right now?
Your Honor, I'm going to object to asked and answered.
Sustained.
So were the kids in any danger whenever you did see them, even after those police reports that took place 5 months ago from now?
During my visits with you, no.
Were the kids well fed, well taken care of, mental health stable? Were they going to visits, counseling? Were they doing everything that I was asked to do in the report?
And
They
Your Honor,
were
in the court order?
I'm going to object. This hearing is about the Miles children. Is she specifically asking about the Miles children, or is she talking about the older children in her home?
I'm asking about all the children.
Well, let's limit questions to these children involved in this case.
Okay. In the case with the children, even in the Miles children, even in December, were the kids around to even sustain any injuries or get hurt or be in danger?
The Miles children?
Yes.
No, they were in Dallas, in the Dallas area.
Okay. So during the December incident, and even before then, I have not put those kids in any danger, correct?
What time period? During my involvement?
Throughout the whole involvement.
During the FBSS case, the children are not in your care to even there be any concern during that time period.
Okay. So also during the last the incident where that case occurred was from July 5th of 2025, correct?
Yes, they were not in your
The
care
reason for it. Mhm.
during my
Right. So they
contact.
were never even. So even during the incident with Kevon, the kids weren't even present to be in danger.
The Miles children were not present, no, during
Right.
that specific
Right.
incident.
Okay. So I think throughout this whole case, it's safe to say that even like if those two kids, the two older ones, don't want to come, Amaya, it's safe to say Amaya has been wanting to come home and see me. And I think, was it or is it not correct that the other kids wanted to visit? They just did not want to live with me.
Your Honor,
I
we
don't object to a compound. Yeah.
compound question.
Sorry.
Okay, let me ask separately. I apologize. So during our conversations, did you not state that the two older ones don't want to live with me, but they want to visit me?
There was times they said that. There was times they did not want to have any contact with you at all. They were going back and forth.
Okay, but Amaya was very persistent, correct?
It was the same with Amaya. There was times she would go to therapy and say she wanted to have visits with you, times that she said she wanted to come see you, and there was times that she would say she did not want to return to your care.
Okay. I don't have any further questions, Your Honor.
Anyone else? Questions? All right, then, Ms. Gutierrez, any other witnesses?
Yes, Your Honor, the department calls Heidi Elliott as its witness.
Ms. Elliott, if you'd raise your right hand. You swear the testimony you give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right, thank you. Ms. Gutierrez.
Thank you, Your Honor. Heidi, who do you work for?
St. Francis Ministries.
And what do you do for them?
I'm a permanency specialist.
And are you assigned to help Ms. Kia Johnson and Andrew Miles with this case?
Yes, ma'am.
And as a part of that, can you tell me what your duties are as a caseworker?
To help parents get set up on their services, offer them resources if needed, facilitate monthly visits with them.
All right. And have you filed a court report for this case?
Yes, ma'am.
And what is the court report asking for at the end as far as recommendations for Ms. Johnson with the Miles children?
That Kia's rights be terminated, that the kids' placement be continued and approved.
Were there previous conversations with me where you had indicated we were asking for her to be a possessory conservator and pay support?
Yes.
So at this point, what exactly are we asking the court to do?
Her rights be terminated.
All right, thank you, Ms. Elliott. Now, as a part of your duties, do you create family plans of service?
Yes.
And have you done that for Ms. Johnson?
Yes.
And that family plan of service, does it aim to mitigate the reasons for removal?
Yes.
As well, was it uniquely tailored or specifically tailored to the needs of the case?
Yes.
Please identify 2 or 3 services for Ms. Johnson that you believe are unique to her.
Drug testing, individual therapy, and parenting.
Okay. And was her service plan made in order of the court at the status hearing?
Yes.
The family-based services testimony may be the most damaging section of the hearing. The worker describes a system that was designed to prevent removal and keep the family together. That matters because it undermines any claim that intervention happened too quickly.
Yes.
Your Honor, we offer petitioner's exhibit number 7, the status hearing order.
Right, objections?
No objection.
Petitioner 7 is admitted.
Thank you, Your Honor. I'm going to go ahead and offer petitioner's number 6 at this time. It's a temporary order following full adversary hearing.
All right, objections?
No objection.
Petitioner 6 is admitted.
Thank you, Your Honor. Now, Heidi, with that status hearing order, petitioner's exhibit number 7. Let's see here. At that time, Ms. Johnson was also ordered to drug screen. Is that correct?
Yes, ma'am.
Okay. Your Honor, we asked for judicial notice of section 6.2 and exhibit number 7.
So noted.
Thank you, Your Honor. Now, specifically, Heidi, she was ordered to drug screen by hair follicle and urinalysis. Is that correct?
Yes, ma'am.
As well as alcohol screen by 4 p.m. on March 30th of 2026. Is that correct?
Yes, ma'am.
Did Ms. Johnson comply with that order to hair follicle drug screen?
No, ma'am.
Did she comply with the order to urinalysis screen?
No, ma'am.
Did she comply with the order to alcohol screen?
No, ma'am.
Okay. And she was present for that hearing as well. Is that correct?
Yes, ma'am.
As far as that status hearing order, can you identify what services she was ordered to do and state whether or not she did each one?
Drug testing, parenting, counseling, and therapy, and rational behavior therapy.
All right. And did she complete any of those?
No, ma'am.
And she was also ordered to drug screen at the adversary hearing. Is that correct?
Yes.
Okay. Your Honor, we asked for judicial notice of section 21 in petitioner's exhibit number 6.
All right, so noted.
Thank you, Your Honor. And Heidi, she was ordered to hair follicle drug screen and urinalysis drug screen. Is that correct?
Yes, ma'am.
Did she do either one of those?
No, ma'am.
She was also ordered to alcohol screen. Did she do that?
No, ma'am.
Okay. Do you believe that Ms. Johnson has mitigated the reasons for removal?
No, ma'am.
Okay. And did she also state at the adversary hearing, or rather the status hearing, that she wanted to relinquish her rights?
Yes.
And to your knowledge, was a copy of that relinquishment provided to her?
Yes, ma'am.
Did she ever turn it back to you?
No, ma'am.
Can you please describe in detail the department's reasonable efforts to reunify the family?
Department has made service plans for Kia, face-to-face visits.
And when you say face-to-face visits, is that with you?
Yes. Well, since she moved to Kansas, I've had to do the visits over the phone.
Okay. And are those visits done monthly?
Yes, ma'am.
And what is the purpose of those monthly visits with Ms. Johnson?
For any updates on her employment, residence, and to follow up on any services.
And have you met each month with Ms. Johnson in this case?
Yes.
And each time have you inquired about her family plan of service?
Yes.
And has she started any services?
No, ma'am.
Do you think it's in the children's best interest that Andrew Miles be named the sole managing conservator?
Yes, ma'am.
Can you please tell me why?
They are happy with Andrew. Their needs are met. They're doing great in school. And they're doing great.
Okay. And in regards to Kia Johnson, can you please explain in detail why it's in the children's best interest that her parental rights be terminated?
They have Well, they just didn't feel like they were protected by Kia. Yes, ma'am.
Do you believe that Miss Johnson has the parental abilities to provide the children with a safe environment?
No, ma'am.
Do you believe that she continues to present a physical danger to the children?
Yes, ma'am.
Do you believe that she also presents a danger to the children's emotional health?
Yes.
What are the department's plans for the children?
To let them remain with their dad, where they're provided for and taken care of.
Okay. And are we also asking the court to stop Mr. Miles's child support since May of 2025?
Yes, ma'am.
And is that of your understanding of when the kids began to live with him?
Yes, ma'am.
Let's see. I pass the witness.
Ms. Mullinax?
Ms. Elliott, there's never been any concerns with Andrew Miles during this case. Is that correct?
No, ma'am, none at all.
The kids have been placed with him the whole time and have done very well, correct?
Yes.
I pass the witness.
All right, Ms. Naranjo?
Miss Elliott, based on your involvement in this case and the testimony and evidence that's been presented today, do you believe that Miss Johnson has knowingly placed or knowingly allowed the children to remain in conditions or surroundings which endanger their physical or emotional well-being?
Yes.
This section exposes a recurring power struggle underneath the legal arguments. The department is no longer discussing past incidents alone. It is discussing control. Concerns emerge about whether the children could remain safely placed with their father without interference.
Based on your involvement in the case and based on the evidence and testimony provided today, do you also believe that Ms. Johnson engaged in conduct or knowingly placed the children with persons who engaged in conduct which could endanger their physical or emotional well-being?
Yes, ma'am.
I'll pass the witness.
All right. Ms. Johnson, any questions for Ms. Elliott?
Yes, sir. During the time that the kids were in physical or in danger or being placed with somebody, how long ago was that?
It was before I received the case.
Okay, is the purpose of all this family-based services and everything, is the purpose to change my behavior and to provide a safe environment for them?
Yes.
So during this whole time, I have taken rational behavior training. I have taken parenting classes. I have done drug tests prior. So would you say all those are reasonable efforts to be the responsible parent I should have been?
During your FBSS case, those things were done, but not during this case.
Do you think doing them 2 times is going to make a difference? Or do you think I have the knowledge?
Your
I
Honor,
think they-
objection, speculation.
Sustained. Next question.
Okay. Did I not make reasonable efforts to go take the drug test?
You did one time that I know of.
Okay. Now, whenever it was ordered that I go take the drug test, did I have proper paperwork?
Yes, you did.
No, for Kansas, because I was already in Kansas at that point.
Objection, Your Honor. If she could give a time frame, I don't know if she's talking about the order from the adversary hearing or the status hearing.
Actually, both of them. Because the first one that was sent, that should be on record, I don't know if it is or not, was during the time I was already in Kansas. The second one, I was sent the paperwork and I went to take the drug test and they didn't have the testing stuff to do that. And I called you, correct?
Your Honor, I'm going to have to object at this point. I think she's testifying. I don't think she means to, but I think that's what's happening.
Yeah, you'll get a chance to testify if you want to, Ms. Johnson, but right now you just ask questions.
Okay. Did I not call you during the time I went to go take my drug test and make you aware that they did not have the proper equipment?
Yes, and I sent it in and it was there the next day when you agreed to go the next day.
I said if I was able to.
You're testifying again.
Is it true? Okay. Is it true that if I just leave work, I could lose my job and that puts the case at risk?
Objection,
well.
speculation.
Sustained.
Okay. For the Miles children, do you know the reason why they went from wanting to see me to not wanting to see me at all?
All they told me back in March was that they weren't protected, that they didn't feel safe in the environment.
And how long ago were they in that environment?
I'm not for sure how long they were in that environment.
No, how long ago has it been since they've been in that environment?
It was before March, I received this case, before May.
Okay, so during this entire well, you haven't been present the entire case. I can't ask you that. But do you think that, or no, not even think, is it possible that they could come back to this environment and be happy?
Objection, speculation.
Fifteen.
All right, no further questions.
Sorry, I'm having trouble with my camera. All right. Anyone have further questions for Miss Elliott?
I have a follow-up for Miss Elliott.
Okay.
Heidi, it looks like the adversary hearing occurred on February 20th of 2026. Do you agree?
Yes, ma'am.
When did you receive information from Ms. Johnson that she had moved out of Amarillo?
It was after that.
It was for sure after that.
Mm-hmm.
Was it prior to the status hearing?
Yes.
Okay. So Ms. Johnson's explanation of why she didn't comply with the court-ordered drug screen in the adversary hearing doesn't sound correct. Would you agree with that?
Yes, ma'am.
I pass the witness, Your Honor.
Anyone else? All right. Miss Elliott, Mr. Miles testified that Miss Johnson last saw the children was in November of last year. Do you show when the last time she had visitation was?
I do not, sir.
Okay. All right. Thank you. All right. Anyone else? All right, then, Ms. Gutierrez, any other witnesses?
No other witnesses, Your Honor. The department rests. We do ask for Mr. Miles's child support to be stopped as of June 1st of 2025. We ask that he be named the sole managing conservator of the children. We ask for termination of Ms. Johnson's parental rights as well.
All right. All right. Ms. Mollix, did you have any witnesses?
I have no witnesses, Your Honor, but I'm agreeable with the department's requests.
Okay. Ms. Naranjo, witnesses?
No witnesses, Your Honor.
All right. Ms. Johnson, do you have any witnesses or do you want to give further testimony?
Yes, I would like to testify.
All right. If you'd raise your right hand, you swear the testimony you give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right. You can tell me what you want to tell me.
Okay. The reason for me not signing over my rights, because I find it very hard to believe that they went from loving me and wanting to be with me to they absolutely want no visitation. And at first I was like, yeah, I'm going to relinquish it, but it just didn't sit right in my head. The older two, if they want to stay there, I'm okay with it. That's fine. Well, I still want to see them. Those are my babies. Like, what mother in their right mind, loving their children? And I've raised the children by myself, not with Andrew's help, not with the other parents' help, any of the parents' help. I've been doing this on my own. I love my kids. Yes, it was in a domestic violence relationship, I have not been in that since July 5th of 2025. My kids have not been in danger, even the older ones, but the Miles children have not. Even in July 5th of 2025, the kids were not present to be in that situation.
Kia Johnson's questioning reveals the central weakness in her defense strategy. She focuses heavily on challenging specific allegations and specific timelines. The department, however, is arguing about broader patterns. Those are two different conversations.
I did what I had to do to protect my kids and to get that guy away because he still has stalking charges and all that because he was not allowed in the house. I have done my parenting classes. I've done everything that I needed to do. And I did that immediately. You've been the judge over this entire case. I love my children. I'm doing everything I can do for my kids. I mean, I'm at a point to where it's like, sorry. This is the most stressful thing in my life I've ever been through because all I've ever been is a mom. I don't want my rights terminated because I love my kids. I don't care how much child support I'd ever have to pay. I want to see them. I want to see them grow. I want to see them prosper. Those are my life. I have been on the right path and doing everything I need to do to be a good mom. Everything that they have brought against to the court is not about me being a mom. It was about the actions I did outside of being a mom. I just want to say that I want to see my kids. I know that if they're with him and he has sole managing conservatorship and I'm not allowed to see them, he will not let me see them. I've been a co-parent to him even whenever he was in San Antonio and he was left with my kids on the street by his ex or by his current girlfriend. I had to drive to Houston from Amarillo the same night to go get my kids. That happened 2 times. There's always somebody or somewhere. I mean, what is being a perfect parent? He's had flaws. I've had flaws. Everybody has had flaws. It's about working on it and being better. And that was the point of this whole case. That is still the point of this whole case, is to be a better person. And that's what I'm striving to be. That's all, Your Honor.
Anyone else have questions for Ms. Johnson?
I do.
All right, go ahead.
Ms. Johnson, you said you hadn't been in a domestic violence relationship since the summer of 2025. Is that correct?
Correct. Yes.
So what occurred on the night or the day of December 7th of 2025 that resulted in police involvement?
I was at Daniel's house. I didn't want to drive home, so a friend was driving my car, and
Ms. Johnson,
I was too drunk to drive.
I'm so sorry to interrupt you. I'm going to ask you to start your answer over. You broke up, and I missed the first part of that. Can you restart your answer, please?
Yes. That night, I was at Daniel's house. We were drinking, and I was too drunk to drive home. So a friend was with me, not a boyfriend, no relationship. A friend was with me, and I told him, I was like, well, I'm too drunk to drive. Can you please drive? And so he was driving, but he was driving stupid. And so I'm like, no, at the next stop sign, I turned off my car. And at that time, I guess he was too drunk too, because that's whenever he bit me in my freaking face. And I got out of the car.
Watch your language, Ms. Johnson.
Okay. But I got out of the car because I did no longer want to be in the car. I'm trying to get out of the situation. It wasn't that. It was a physical fight. It wasn't anything that it was like, well, not on my end. But I was trying to be responsible and not drink and drive. And it turned out worse than what it should have been. So I got out of the car and I took off walking. And that's whenever the police came. And you've seen the pictures. Y'all see the pictures. It was embarrassing. It was everything. I mean, that's what happened that night. But it wasn't a domestic relationship. My kids were not involved. My kids were nowhere around. I did not put my kids in any danger.
Who was it that hurt you?
It was Brandon.
What is Brandon's last name?
Rice.
And he's the one that the court actually ordered not to reside at your house. Is that correct?
Yes, and he was not residing at my house at that time.
But you saw him again, and this incident occurred in December of 2025, correct?
Yeah, I seen him again. He was my friend.
Okay. Now, you mentioned that you had done all the services. Is that correct?
Yes, I did.
However, that was during the family-based case and not since the start of this removal case. Is that correct?
What makes a difference?
That's not an answer. That's a question. That's a yes or no question.
That is correct.
Okay. So since the start of this removal case, have you done your parenting?
No, I asked for a copy of the service plan, which I have not received.
Okay, but we have you in our service contacts. And so yeah, that was
What?
e-filed to you. That was sent to you. That was sent
When?
to you. Your Honor, I asked for judicial notice of that status hearing order again, including the e-file certificate at the end.
Sustained.
When was that sent to me?
I've taken notice of it already.
Thank you, Your Honor. Now, Ms. Johnson, you agree that all these services were reordered by the court. Is that correct?
I don't agree because I did not see it.
Well, you were present in that hearing, correct?
What was ordered was the drug testing.
Your Honor, I pass the witness.
Right. Anyone else have questions for Ms. Johnson?
Just briefly, Your Honor.
Okay.
Ms. Johnson, where do you work?
I work at FedEx.
And how much do you make at FedEx?
It's a daily rate. So it could be from it's $150 a day or $300 a day. It just depends.
And on average, what's your daily rate?
The permanency specialist's testimony shifts the focus from history to accountability. The department begins measuring compliance against court orders rather than personal explanations. This is where the legal pressure intensifies. Family courts place enormous weight on whether parents follow direct court instructions.
On contingency, which is why I'm in Kansas right now, is $300.
So you make
It's a
$300 a day?
month-to-month contract.
And do you have health insurance through this employment?
No.
I'll pass the witness.
All right. Anyone else?
Sure. Ms. Johnson, how many days a week do you work?
Sometimes 3, sometimes 6.
And what
On
is your average?
contingency, on contingency, I work 7 days a week.
No further questions, Your Honor.
Anyone else? All right, then. Any further witnesses from anyone? All right, then. I'm going to take about a 5-minute break, and then I'll be back, and I'll get recommendations from Ms. Naranjo.
Thank you.
Your Honor.
In the event that the court does terminate Ms. Johnson's rights, we ask for a finding of reasonable efforts to reunify.
All right, I will make those findings regardless of the court's ruling.
Thank you, Your Honor.
Okay. All right, Ms. Naranjo, your recommendations?
Your Honor, I do believe it's in the children's best interest that Ms. Johnson's rights be terminated today and that Mr. Miles be named the sole managing conservator of the children. If the court does decide not to terminate Ms. Johnson's rights, I would ask that child support be set based on her testimony today.
All right, thank you. All right, then, based upon the evidence I've heard today, as well as the exhibits that have been admitted, I do find, first of all, that it's in the best interests of the children, Amaya Miles, Malaysia Miles, and Ja'Cory Miles, that the parental rights of the mother, Kia Johnson, be terminated. I'll terminate those rights today based on Texas Family Code Section 161.001, subsection B1D and E. I further find that it's in the 3 children's best interest that Father Andrew Miles be appointed sole permanent managing conservator. I also will make a finding that Mr. Miles' child support, it's ordered that his child support should have and did. I'll order that it cease, and any medical support also as of June 1, 2025. The department and all other court-appointed relationships will be dismissed after all appellate and de novo periods have expired. Ms. Johnson, I need to admonish you on a couple of things, 3 things actually.
Yes, sir.
You have the right to ask for what's called a de novo hearing before the referring court. In that case, the referring court would be the 251st District Court of Randall County, Texas. To do so, you must file with the Randall County District Clerk and give notice to the 251st District Court of your intent to ask for a de novo hearing before the referring court, not later than the 3rd working day after the date you received notice of the court's ruling, which you just received notice of. So 3 working days from today's date.
Okay.
If you file that de novo request, you have to specifically set out the issues that you want presented to the referring court when you have that hearing. Also, you have the right to appeal the court's decision to the Court of Appeals, 7th Court of Appeals in Amarillo. If you do that, this is what's called an accelerated appeal, you must file a notice of appeal within 20 days after the date that I signed the judgment, which I've just rendered. So it's not from today, it's from when they present me the order and I sign it.
Okay.
And then finally, you have the right to an attorney for your appeal. If you can't afford an attorney, you have the right to ask the court to consider whether or not you're entitled to a court-appointed attorney at no cost to you. You do that by filing an affidavit of indigency, which you can get from my office, probably from anyone with St. Francis or the department. It has to be filled out completely and presented back to my office before I can consider whether or not you're entitled to a court-appointed attorney. That I would have to find that you're indigent. Do you understand all? You understand
Yes,
all
sir.
the rights I've just explained to you?
I do.
Okay, thank you. All right, since we have a final resolution in this case, there'll be no further hearing set.
When Kia Johnson finally testifies, the case becomes a clash between emotional conviction and institutional evidence. Her testimony is built around love, effort, and the belief that the children's feelings changed too dramatically to be genuine. Emotionally, that argument has force. Legally, it faces a much tougher challenge. Courts rarely decide these cases based on who loves the children more. They focus on risk, consistency, and future stability. Her testimony attempts to redirect attention toward personal growth and past service completion, while the department continues emphasizing unresolved concerns and recent non-compliance. The judge is left weighing two competing narratives. One says, a mother has changed and deserves continued connection. The other says, the children's need for safety and permanence outweighs that opportunity. That is the real conflict driving the final decision.